12 strangers will decide if you go free or spend life in prison. And before they hear a single word of evidence, lawyers have already fought a hidden war to choose them. This is voir dire. The secret process that wins cases before trials even begin. Here is what most people never realize. The trial you see on television starts too late. The real battle happens days before. Voir dire is French for speak the truth. But the truth lawyers want has nothing to do with honesty. They are hunting for bias, hidden prejudices, unconscious leanings you do not even know you carry. Every question has a purpose. Every answer reveals something. That fidget when discussing police. That pause before answering about fairness. Lawyers catalog everything. Because the wrong juror can destroy months of preparation in one deliberation room vote. Defense attorneys and prosecutors want completely different people in those 12 chairs. And what separates good lawyers from great ones? Knowing exactly who to eliminate. But here is the question nobody answers. How do they actually know? The process starts before anyone enters the courtroom. Jury consultants analyze questionnaires for red flags. Occupation matters enormously. Engineers and accountants demand evidence. Teachers often sympathize with authority. Nurses understand trauma. But stereotypes are just the beginning. If this is changing how you think about jury trials, that like button helps more people discover these courtroom secrets. The real intelligence comes from community research. What newspapers does this county read? How did they vote in the last election? What local scandals shaped their worldview? High-profile cases bring demographic analysis. Age distributions. Income patterns. Racial composition of the jury pool. Defense teams in wealthy zip codes face different challenges than those in working-class districts. And all of this happens before the first juror ever takes a seat. But here is where it gets strategic. When potential jurors finally sit in that courtroom, lawyers have roughly 40 minutes each to question them. Sounds simple. It is anything but. The questions are psychological warfare. Prosecutors ask about respect for law enforcement. About following rules even when you disagree. They want rule followers. Conformists. People who trust institutions. Defense attorneys probe differently. They ask about times you were wrongly accused. About second chances. About reasonable doubt being a sacred protection. They want skeptics. Independent thinkers. People who distrust power. Watch any trial. The questions reveal everything about trial strategy. A prosecutor asking about your views on circumstantial evidence. They have weak physical proof. Defense focusing on police misconduct. They plan to attack the investigation. Every question is a chess move disguised as conversation. Now imagine you are the defense attorney. And this is where lawyers earn their reputation. Your client is accused of a violent crime. The prosecution presents a retired military officer. Decorated. Disciplined. Follows chain of command. On paper, terrible for your case. But you listen. He mentions his grandson was falsely accused of vandalism last year. His voice tightens when discussing it. That detail changes everything. This man knows what wrongful accusations feel like. He becomes your ideal juror. Meanwhile, a young social worker seems perfect for defense. Empathetic profession. Believes in rehabilitation. But she mentions her sister was a crime victim. That experience overrides everything else. You must eliminate her. The art of voir dire is hearing what people do not say. Reading the hesitation. The emotion beneath the words. The best trial lawyers are part psychologist, part detective. But that is just the beginning of the strategy. And now we reach the most controversial tool in jury selection. Peremptory challenges. Each side can dismiss a certain number of jurors without giving any reason whatsoever. No explanation required. The judge cannot stop it. The dismissed juror never knows why. This power has shaped American justice for centuries. And it has been weaponized in disturbing ways. Prosecutors in some jurisdictions systematically eliminated black jurors from cases involving black defendants. The Supreme Court addressed this in Batson v. Kentucky in 1986. But enforcement remains problematic. Studies show racial bias in peremptory challenges continues today. If you want to understand how verdicts really happen, make sure you are subscribed. Defense attorneys face their own dilemma. Use challenges to eliminate law enforcement families. You might appear anti-police. Save challenges for worse jurors. That cop's wife stays on your jury. What really happens in those critical moments when attorneys must decide? Think about this carefully. Here is what trial veterans know. The juror who talks too much during voir dire often becomes a foreman. Leaders emerge early. The quiet observer in row 3 might be your biggest ally or your worst enemy. You simply cannot tell. Body language experts advise watching feet. Arms can be controlled. Feet rarely lie. Crossed ankles signal discomfort. Feet pointed toward the exit mean this person wants out. Most critically, attorneys watch how jurors interact with each other. Who makes eye contact across the room? Who seems to influence others already? Because jury deliberation is not 12 individual votes. It is group dynamics. One strong personality can sway the entire room. The lawyer who identifies that personality during voir dire gains massive advantage. Drop your prediction in the comments. Which profession do you think prosecutors fear most on juries? And this is where everything comes together. So what makes the perfect juror? The answer reveals the entire system. For prosecutors, the ideal juror believes authority figures, trusts forensic evidence without question, and considers defendants probably guilty since they were charged. They want conformity, deference, quick decisions. For defense, the perfect juror demands proof beyond any doubt, distrusts government power, and believes in redemption. They want skepticism, independence, thorough deliberation. But here is the truth nobody advertises. Both sides want jurors who will follow their emotional narrative, not just the evidence. The prosecutor wants someone who feels outrage at the crime. The defense wants someone who feels sympathy for the accused. Voir dire is not about finding fair jurors. It is about finding jurors who are unfair in your favor. This is the hidden reality of American justice. The next time you receive a jury summons, remember this. You are not being evaluated for fairness. You are being evaluated for leanings. Every answer you give, every reaction you show, tells both